Good afternoon, Mr. Schmidt. Are you ready on anyone?
Hello. I'm ready on everyone.
All right. Who would you like to call first?
Um, Nicholas Barden.
Mr. Barden, if you'll come forward. This is cause number CR 25-191, State versus Nicholas Bradley Barden for docket call.
Judge, we're going to ask for a final docket call setting on Mr. Barden.
Any objections from the state?
No objection, Your Honor. Thank you.
All right. Court will set Mr. Barden for final docket call on March 31st, and then he can announce how we're going to resolve the case.
Yes, sir. Thank you.
Who's next?
Glass.
Robert Wayne Glass, CR 25-201 for pretrial. Go ahead.
Judge, no contested motions at this time. I ask for that docket call setting.
All right, court says Mr. Glass for docket call March 31st at 1:30.
Robert McIntyre.
Robert Walter McInturf, CR 26-4. Mr. McInturf set for arraignment.
That's correct, Judge. We've received a copy of the indictment. His name is spelled correctly. He understands the charges. We'll waive reading and enter a plea of not guilty and ask for a pretrial setting.
All right, court finds Mr. McInturf waived the formal requirements of arraignment. The court enters his plea of not guilty into the record, sets this matter for pretrial on March 31st at 1:30. If he makes bail, his hearing will be at 9 a.m.
Yes, sir. Thanks. Brandon Creel is on your docket, Judge. I asked that he not be brought up. He is obviously still incompetent. I think the court has the intentions of having him evaluated for involuntary medication.
Yeah, let me go ahead and put this on the record. This is cause number CR 23-158, CR 24-206, 2025-92, 2025-98, State versus Brandon Ashley Creel. The court finds that Mr. Schmidt, counsel for Mr. Creel, has waived his appearance today. The court approves his non-appearance, and you're correct, Mr. Schmidt. The court has requested for Dr. Corman of the Andrews Center to evaluate him for possible administration of medications, and I believe that's going to be happening in the next week or two. So we can go ahead and we'll reset this for status. Are you, remind me on the status of the insanity evaluation? Is that something that's already occurred, or just refresh the court's record?
No, Judge, because he's been deemed incompetent, they will not proceed with the sanity evaluation until he's either restored or otherwise. And so therefore I have not retained that expert at this point, knowing that he's been deemed. I don't want to waste the court's money. But I do know that Mr. Hartwell and I have discussed potential resolutions given the status of Mr. Creel's mental health, and I intend to meet with Mr. Hartwell shortly with hopefully a plan to move him forward.
All right, court will set Mr. Creel then for status on March 31st for the court-ordered meds and just general status. And obviously, if Dr. Corman finds that he needs court-ordered medication, then that will be filed, and we'll set that for a hearing. We'll come back.
Yes, sir. I do believe the rest that I have are pleas, Judge, and they should all be in your queue.
Let's go with the order that I've got them here. Samantha Main, is she in there?
Yes, sir. Come on down this way.
This is cause numbers CR 25-155 and CR 25-169. State of Texas versus Samantha Laverne Main. And Miss Main, if you will raise your right hand, I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Larry. Give me just one moment. I'm going to look through your plea agreement here.
Nice.
Okay. Mhm.
Let's see. All right, Miss Main, some questions for you. Are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you are represented by your attorney, Mr. Richard Schmidt. Are you pleased with him as your attorney and the work that he's done?
Yes, sir.
Do you understand everything that you've read and signed as part of your plea agreement today?
Yes, sir.
Do you have any questions about anything before we go further?
No, sir.
Mr. Schmidt, do you believe Ms. Main to be competent to enter into plea agreements in each case? And if so, that she's doing it intentionally, knowingly, and voluntarily after having been informed of her legal rights?
Yes, sir.
All right, and cause number CR 25-155, Ms. Main, I see that you are charged with a first degree felony offense of manufacture or delivery of a controlled substance. It appears that the agreement today for you would be upon you pleading guilty to the lesser included offense of possession of a controlled substance. Okay, counsel, help me out. So I see that she's indicted with, it says lesser included, but it's still a first degree felony with the same range of punishment, with the same quantity range. Is there a lesser I'm missing here?
Yes, Your Honor. So the indicted charge, Mandel, of 2 to 400, has a minimum punishment of 15 years. So by dropping it to just possession, that drops that minimum punishment off.
All right, thank you, Mr. I didn't see the dropping of the Mandel. Okay, thank you. All right, so Ms. Main, the plea agreement looks like upon you pleading guilty to possession of a controlled substance, a first degree felony, the state's recommending that you be convicted of that offense, that you be sentenced to 5 years in prison, that you be ordered to pay a $1,500 fine, restitution of $180, court costs of $290, and reimbursement fees of $40. And the DA's office, as part of the plea agreement, is agreeing to dismiss cause number CR 25-169. I'm sorry, take that back. They're agreeing to dismiss possession of marijuana less than 2 ounces and a possession of controlled substance, penalty group 3. And they're recommending that your sentence run concurrent with your plea agreement and sentencing cause number CR 25-169. In CR 25-169, you were indicted with abandoning or endangering a child. And it looks like the plea agreement in that case is upon you pleading guilty to that charge, they're recommending that your punishment be assessed at 6 months confinement in the state jail division of the Texas Department of Criminal Justice with your sentence running concurrently or at the same time as your other sentence. And you would be responsible financially for court costs of $290 and reimbursement fees of $40. Mr. Schmidt, what kind of credit time, if any, would Ms. Main be receiving towards these sentences?
297 days, Judge.
297?
Yes, sir.
All right, so Ms. Main, if the court accepts the plea agreement, you would also receive your credit time of 297 days. And so, Ms. Main, is that your understanding of the plea agreement today and what you're asking the court to approve?
Yes, sir.
All right, then in cause number CR 25-155, I'd ask you, how do you plead to that offense of possession of a controlled substance, penalty group 1, greater than 200 grams, less than 400 grams?
Guilty.
In cause number CR 25-169, how do you plead to the charge of abandoning or endangering a child?
Guilty.
Are you pleading guilty to each one of those crimes because you are guilty of committing each crime?
Yes.
Ms. Main, has anyone threatened, forced, or pressured you to plead guilty to either crime?
No.
All right, the court will accept the defendant's plea of guilt at this time. Mr. Schmidt, any objection to the stipulation of evidence?
No objection.
All right, the evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
From the defense?
No, sir. So,
All right, the court will consider the evidence in each case at this time.
nice try.
I'm a good girl.
All right. Just wait for it.
Hang on, Ms.
Hold
Main.
on. Come back when it.
I'm sorry.
You're okay.
I gotta
I'm
help myself.
still reviewing the evidence, and then I'll have to tell you if I'm going to follow your plea agreement. Several things. So give me just a moment. All right, the court, having reviewed the evidence, finds enough evidence to convict the defendant of the offense. The court will follow the plea agreement between the state and the defense in cause number CR 25-155. The court convicts Samantha Laverne Main of possession of a controlled substance greater than 200 grams, less than 400 grams. Court hereby assesses punishment, which is consistent with the range of punishment in this case at 5 years confinement in the Texas Department of Criminal Justice. The court orders her to pay a fine of $1,500, court costs of $290, restitution of $180, and reimbursement fees of $40. The court orders the sentence imposed in this case to run concurrent with cause number CR 25-169, abandoning, endangering a child. The court dismisses the two offenses under section 1245 included in the plea agreement. In cause number CR 25-169, court hereby convicts the defendant of abandoning or endangering a child, a state jail felony. The court assesses punishment pursuant to the plea agreement at 6 months confinement in the Texas Department of Criminal Justice, State Jail Division. Court orders this sentence to run concurrent, cause number CR 25-155. Court orders the defendant to pay court costs of $290 and reimbursement fees of $40 in this case. Ms. Main, when you are released from the Texas Department of Criminal Justice, if you've not paid off your fines, fees, restitution, things of that nature, you need to report here to the courthouse and pay those off. Going to prison and getting released from prison does not wipe your record clean as to what you owe. This is part of the judgment. You're going to go serve your time down there, but you're also ordered to pay the fines, court costs, and fees. Failure to do so could result, even after you get out of prison, of having an arrest warrant sent out for you to be picked up. You understand? So
Yes, sir.
report to the courthouse, and if you haven't paid it off by the time you get out of TDC, then make arrangements to get on a payment plan and take care of it. Okay?
Yes, sir.
All right, Ms. Main, you hereby remanded to the custody of the sheriff. Please step over to be fingerprinted. Mr. Schmidt, go ahead and get your next client. Well, I'm gonna assign these real quick.
Okay. So yeah, I'm gonna
You can see what you do. It's done messed up. Oh, it's good. Okay.
This kind of off the charges too, right? Yeah, we probably have seen this one time. Never done it long ago, right? So. It's hard to- It was weird, right? She had a. Look up and I couldn't.
You can sign.
Oops, they gotta go to the. Yeah, he's a body here. I just looks, he's actually a pretty nice fella. Yeah, but they're not gonna see going on.
Oh, that means it's not.
And she's out. You see? Yeah, you can see, you can hear you too.
That's good.
All right, Mr. Schmidt, who do you have next?
This is Mr. Marshall.
All right, this is cause number CR 25-269, State of Texas versus Michael Paul Marshall. And it's a plea today. Is that correct, Mr. Schmidt?
That's correct, Judge.
All right, Mr. Marshall, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
Thank you, Lord. Is your name Michael Paul Marshall?
Yes, sir.
And Mr. Marshall, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt and the work that he's done for you?
Yes.
Do you have any questions about your plea agreement, the paperwork, or anything else that you've reviewed in this case?
No, sir.
All right. Mr. Schmidt, do you believe Mr. Marshall to be competent to enter into a plea agreement? And if so, that he's doing it intentionally, knowingly, and voluntarily after having been informed of his legal rights?
Yes, sir.
All right, Mr. Marshall, you are charged by indictment with a third-degree felony of evading arrest or detention with a vehicle that does carry a range of punishment of not less than 2 years in prison or more than 10 years in prison. I see the plea agreement in your case is for you to plead guilty, and the recommendation is 3 years in prison, along with a $1,000 fine plus court costs of $290 and reimbursement fees of $20. Is that your understanding of the plea agreement?
Yes.
All right, understanding the plea agreement and the range of punishment, Mr. Marshall, how do you plead to evading arrest or detention with a vehicle?
Guilty, sir.
And are you pleading guilty to that crime because you are guilty of committing the crime?
Yes.
And has anyone threatened, forced, or pressured you to plead guilty today?
No, sir.
All right, the court does accept the defendant's plea of guilt. Mr. Schmidt, any objection to the evidence?
No objection.
The evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Mr. Schmidt, how much credit time would Mr. Marshall be entitled to?
151 days.
151. Okay. Anything further from the defense?
No, sir.
All right, then the court is going to view the evidence at this time. All right, the court, having reviewed the evidence, finds enough evidence to convict the defendant. Court follows the plea agreement. Court convicts Michael Paul Marshall of evading arrest or detention with a vehicle, third-degree felony. assesses punishment pursuant to plea agreement at 3 years confinement. The Texas Department of Criminal Justice Institutional Division court orders him to pay a $1,000 fine, $290 in court costs, and $20 in reimbursement fees. And the court awards him 151 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Marshall, you hereby remanded to the custody of the sheriff, and I'm gonna have you step over to be fingerprinted.
All right, thank you.
You're welcome.
See it right.
Mr. Schmidt, if you want to go ahead and get your next client, sign these papers. All right, who do you have, Mr. Schmidt?
This is Miss Jacobs.
Calls number CR 24-235, State versus Jennifer Lynn Jacobs. Ms. Jacobs, if you will raise your right hand, I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, thank you. You can put your hand down. Ms. Jacobs, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with him as your attorney and the work that he's done for you?
Yes, sir.
Do you have any questions about your plea agreement or anything else?
No, sir.
All right, Mr. Schmidt, do you believe Ms. Jacobs to be competent to enter into this plea agreement and that she's doing so intentionally, knowingly, and voluntarily after you've explained her legal rights?
Yes, sir.
Have you all also discussed the advantages and disadvantages of a deferred adjudication plea?
In detail, yes, sir.
All right, Ms. Jacobs, you are charged by indictment with a second-degree felony offense of possession of a controlled substance. Penalty group 1, a second-degree felony carries a range of punishment of not less than 2 years in prison or more than 20 years in prison, and a possible fine not to exceed $10,000. In this case, I see your plea agreement is for you to plead guilty to that offense. The state would be recommending that the court consider the evidence but not convict you of the offense. They're asking the court to place you on community supervision for 7 years. As part of the agreement, you would also be paying a fine of $1,500, restitution of $180, plus court cost of $290 and reimbursement fees of $605. In addition, there's a driving while license invalid with previous conviction. The state would be dismissing that case pursuant to your agreement in this case. Is that your understanding of the plea agreement?
Yes, sir.
All right, understanding those things, I would ask you, Ms. Jacobs, how do you plead to possession of a controlled substance in penalty group 1 greater than 4 grams, less than 200 grams, a second-degree felony?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
All right, court accepts the defendant's plea of guilt. Mr. Schmidt, any objection to the evidence?
No objection.
All right, the evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
No, sir.
Court will review the evidence at this time. Right, the court having viewed the evidence, finds enough evidence to convict the defendant. The court follows the plea agreement today. The court hereby defers the finding of guilt, places the defendant on 7 years community supervision. The court also orders her to pay a $1,500 fine, restitution of $180, court costs of $290, reimbursement fees of $605, and the court dismisses DA number 2023-1048, driving while license invalid. All right, Miss Jacobs, you're hereby remanded to the custody of the probation department. I'm gonna have you step over to be fingerprinted. After that, the probation officers will give you more info.
Oh, that's okay.
All right, Mr. Schmidt, do you have any other clients that are ready?
We do have, well, Mark Martinez is on the docket, Judge. I believe he's in TDC custody.
Yeah, court call CR 25-97 and CR 25-122. I think we're set today for status on prosecution.
That's my understanding.
Your Honor, I haven't been able to get a hold of a judgment for Mr. Martinez yet. If we get one more status, while I can work on tracking that down, I can get the court either a request for bench warrant or a disposition.
It's my understanding that he had a parole hold.
Yeah, that's, I'm guessing, because it
So-
looks like his two charges were quite old. He had an aggravated kidnapping in Smith County in 2009.
Right.
But had a 17-year sentence for that. And then, so that's probably what he's got the hard parole on. So anyway, that case number, Mr. Hartwell, is 007, like 007 -1347 -09 out of Smith County.
Thank you, sir.
All right, court will reset Mr. Martinez for status on March 31st. 1:30 in each case.
I believe that's all I have this afternoon, Judge.
All right, thank you, Mr. Schmidt. Appreciate your work.
Yes, sir.
Mr. Sanders is now in the waiting room. Is this Mr. Guevara Salazar?
Sorry, sir.
All right. I'm gonna bring your attorney in here, Mr. Sanders. You're okay, Mr. Sanders. We'll give you time where you can stop and you're good. We got time. You're on mute.
Second nicest lawyer on the
There we
planet.
Mountain,
Okay.
mountain.
It's not.
Can you hear me?
Yes, are you ready now?
Yes, yep.
All right, this is cause number CR 25-251 and CR 25-252, State of Texas versus Anthony Guevara Salazar. And Mr. Guevara Salazar is set for pretrial in each case. Any announcements, Mr. Sanders? I'm sorry, there's also a third case, CR 25-253. So any announcements?
Yeah. Judge, at this time, he has a pending felony from the same incident in Smith County that was just on the other side of the Smith County line. And so if we could reset this for another pretrial in March, I should have a better, that case in Smith County has been indicted now, so I should have a better idea of how we can kind of wrap everything up together by the end of March, if that would work for the state.
Any objections from the state?
No objection, Your Honor.
All right, court will grant that request. Mr. Sanders, court sets Mr. Guevara Salazar for additional pretrial March 31st at 1:30. In each case, if he makes bail, then his hearing will be at 9 a.m. And so, Mr. Guevara, if you make bail in this case, you need to notify your attorney so that he knows that you're out, and then your hearing will be at 9 a.m. Do you understand?
Sorry, sir.
All right, you're free to go.
Yes, sir. Thank you.
Thank you, Judge.
You're welcome. See you, Mr. Sanders.
All right. Have a good day.
You as well. All right, I believe that does conclude the court's afternoon criminal docket. I appreciate everyone's hard work, and the court is adjourned.
Thank you, sir. Have a good one.
You as well.